Good morning, good morning, good morning. It is Monday. It's July 1st. I'm still working with a little bit of a cranky voice, but it's been a lot of talking between, 31 days of evidence in this case, 75 witnesses, plus a week of VidCon, plus 2 Dave Matthews concerts. My voice is a little bit tired with me, lots of air travel. And as we were about to go live today, all of the internet crashed where I am because I am still mobile. Here's what's going on today. The jury was sent out Friday to basically think about it over the weekend. Right before they were supposed to go to lunch, so right before 1 p.m. local time in Boston, the jury came back with another note indicating again that they are deadlocked. The judge has not declared a mistrial yet, but the judge will at some point today likely be declaring a mistrial. Now, we're going to talk about what happened in court. We're going to talk about what it means, and we are going to go from there. So, Love Two Limes, I know I sound awful. I was not expecting to stream this early today, and I did not have time to do vocal warm-ups. So, my voice is just my voice. I feel fine, but my voice is again 30 days of trial, 5 days of VidCon, 2 Dave Matthews concerts. So I wasn't going to leave you guys hanging. So let us get into what is going on in court. We're going to go to what the jury question is, what the lawyers have said about it, and what the judge told them to do, and then what happens next. So, you guys ready? We're going to roll the intro. We're going to go to court. I love that Dawn's like, the voice is sexy AF. I mean, yeah, we're going to lean in. We're going to lean into that a little bit today, but no, it is tired and I get it. All right. So let us roll to the intro. Let us roll to court. And then I'm going to explain everything that's happening. All right. And then we'll do some questions. I imagine that I will be doing 2 streams today. We're going to do this one. We're going to, the jurors are at lunch. We're going to do this one. And then when the jury comes back at some future point today, unless they come back while I'm still live, if the jury comes back at some future point today, I'll go live again. All right. So with all of that, thank you all for your patience. I know you were looking for me when court came back this morning. The mobile setup was not set up yet. So it just takes a minute on the road. So I appreciate all your patience. I can't wait to be back in my setup for the week. You guys, I go home tonight. I changed flights though. This jury wasn't going to catch me on a plane. This jury was not going to catch me on a plane. I changed flights, so I'm here for you all day. Let us go. We need you to sing a chorus of Smelly Cat. Yeah, that's exactly where I'm at right now. All right, let's roll, shall we?
Hey there, I'm Emily D. Baker, the internet's go-to legal analyst, breaking down the legal side of the pop culture and entertainment stories we can't stop talking about. I'm a big fan of the cursey words. I've been a licensed attorney for over 17 years, but this is not legal advice. This is where the law nerds unite to talk about facts, not... Let's get into it.
Right, everybody, let's go back to court. So, again, the jury's been deliberating since Tuesday. They've not been deliberating quite a full week yet. Generally, in a case like this, I would have expected to see a verdict back much quicker. The reason we didn't, and we learned on Friday, is because they are deadlocked. Again, they have reiterated that they are deadlocked. We're going to watch what happened in court, then the charge that the judge gave them, and then we're going to go forward. All right, let's roll.
You are unmuted.
We're back on the record on the Karen Reed, Your Honor. We've got a question from the jury.
All right. So, Mr. Lally, I'd like to hear from the Commonwealth first about doing thorough deliberations.
The reason the judge is immediately asking Lally about due and thorough deliberations is because at what point do we declare that this jury is hopelessly deadlocked or hung and then declare a mistrial? So with that, the judge is asking for the state's and then the defense's input. And this means the lawyers have already seen the note, right? The lawyers have already seen the note. They know what's going on.
Sorry, I didn't hear the last one.
I'd like to hear from the Commonwealth first about your view on whether the jury has conducted due and thorough deliberations.
Your Honor, while I understand that they have been at this for a while, I would submit that they have not, and I would ask the court not to make such a finding.
Lally's like, let them deliberate forever. Just leave them here until they're tired. Just leave them here till they're tired.
Reasons for that, Your Honor. This jury heard, I believe, about 29 days or so of testimony, 657 different exhibits marked as evidence, 74 different witnesses who testified.
Did you catch what he said? 607 exhibits.
Before them. And while I believe they've been out for somewhere in the vicinity of 22 or 23 hours, what I would submit to the court based on all of that, as well as the complexity of the issues presented to them, they really haven't even had 1 hour of deliberation equivalent to 1 day of testimony, to each of the days of testimony that they've heard. So while they have been at it for a while, I would submit that based on the evidence and testimony and witnesses and the complexity of issues in this case, I would submit that they have not done a thorough deliberation up to this point.
Ms. Tianetti?
Our view is that it's time for Tui Rodriguez, Your Honor. They've come back now twice, indicating essentially that they're hopelessly deadlocked. The content of this latest message is that they have been over all the evidence. Previous message said they did an exhaustive review. This time they said that they have fundamental disagreements about what the evidence means. And it's
What Yannetti is saying, and he's a little hard to hear just because he's standing and a little bit back away from the mic. Fundamental disagreements. That means they do not see the evidence the same way. They're seeing the same evidence, and one juror is going, it means this, and another juror is going, it means that, and they cannot bridge that gap. We do not know how many jurors are on one side or the other. We do not know if they are hung in different ways. And by that, I mean, you can have jurors that are split 11-1 on one charge and 6-6 on another charge, because there are 3 charges here. So you can have jurors split in different ways depending on the charges. So we just don't know. Thank you guys for not speculating about that. We don't know. So what they are going to do is a Tui Rodriguez's instruction. Sometimes that is called an Allen charge. It is a very strong charge. So we're going to talk about that real quick, and we're going to hear the jury's note when the judge comes back, and we're going to hear the jury's charge when they come back.
a matter of opinion. It's not a matter of lack of understanding. This court, when you sent the jury out, encouraged them not to take a straw vote, encouraged them to go over all the evidence in a very methodical manner. I think all indications are that they've done that, and this is what Tui Rodriguez is for. We asked the court to get it.
Yeah. All right. I think this has been an extraordinary jury. I've never seen a note like this reporting to be at an impasse. I do find that they're now, with the additional time that they went out without coming back Friday saying that they were deadlocked,
They did
is
take
doing
time.
thorough deliberation. So I'm
Yes.
going to give Tui Rodriguez.
I agree with the
So
judge.
are they ready to come in, Jody?
No, I don't think this jury's going to change their mind. Carrie in the chat asked, can they not go for a majority verdict? They have to be unanimous, whatever it is. In the U.S., you have to be
So why don't I
unanimous.
take a recess?
We're going to zoom to get to the court instructing the jury. They have to be unanimous, either guilty or not guilty. They cannot have a split of anything in criminal. In civil law, it is different. But in criminal, you must be unanimous. And they could be unanimous. They didn't say that here. They didn't say that we have a verdict as to some charges, but not all. That can happen too, where the jury can come back on one charge with a verdict and not on others. They didn't say that. They say they have a fundamental disagreement of the evidence, and we're going to listen to that now. So we're going to go back into court and listen to the note, listen to what the jurors say, which is going to inform why I think they're going to come back later today and the court's going to excuse them. And we're going to listen to this instruction. Remember, the court told them they needed to come to a verdict unanimously and to a moral certainty. The case needed to be proven to them beyond a reasonable doubt and to a moral certainty. That, to a lot of folks, is going to feel like, all right, if I'm not certain, I'm not changing my mind. Would you? If you were sitting on this jury and you felt very strongly one way or the other, would you change your mind? Could anyone change your mind at this point? If you're sitting in the chat thinking that Karen Reed was involved in this death and she caused the chain of events that led to his death, which is one of the lesser included, could you change your mind? If you're sitting there going, the Commonwealth 100% did not prove their case, that man was not hit by a vehicle, would you change your mind? Would anyone change your mind on that? And that's where this jury is. And I get it. I can't imagine a jury that thought that Karen Reed was not guilty, who felt that the Commonwealth hadn't proved this case. I can't imagine them changing their mind. I can't. So let's hear what the judge has to say in this instruction. It is a strong instruction. It is meant to shake the jury out of their deadlock. That doesn't often work. In fact, I've seen it work fairly rarely, but let's see what this jury's question is and the judge's instruction. No, we were just where we needed to be. I was so close. I was so close. We're gonna have to zoom a little bit more. Sorry, chat. That was me. I tried to get us queued up perfectly. I did it badly.
Court is in session. Please be seated.
All right. So, jurors, I am in receipt of your note. Judge Cannoni, despite our commitment to the duty entrusted to us, we find ourselves deeply divided by fundamental differences in our opinions and state of mind. The divergence in our views are not rooted in a lack of understanding or effort, but deeply held convictions that each of us carry, ultimately leading to a point where consensus is unattainable.
Deeply held convictions to a point where consensus is unattainable. They are saying to the judge, we understand. You can't fix this for us. We have deeply held beliefs and we cannot bridge that gap. That is a very, very, very strong note from the jury. I'm going to go back to the beginning again, because listen to the way this jury words it. They're not, the first time they came back and they were undecided, they were really clear with the judge. They said exhaustive review of the evidence. But this time they're coming back and saying, this is a deeply, deeply held disagreement. They're telling the judge they're done.
So,
like
jurors, I am
done.
in receipt of your note. Judge Cannoni, despite our commitment to the duty entrusted to us, we find ourselves deeply divided by fundamental differences in our opinions and state of mind. The divergence in our views are not rooted in a lack of understanding or effort, but deeply held convictions that each of us carry, ultimately leading to a point where consensus is unattainable. We recognize the weight of this admission and the implications it holds. So, Mr. Foreman and members,
they have told the judge, we absolutely understand. We absolutely understand. We know the implications of this. We know that this has been a 30-day trial. We know that there's been, 600 pieces of evidence. We know, but we cannot get past it.
of the jury, I have an instruction for you. Our Constitution and laws provide that in a criminal case, the principal method for deciding questions of fact is the verdict of a jury. In most cases, and perhaps strictly speaking in all cases, absolute certainty cannot be attained, nor is it expected. The verdict to which each juror agrees must, of course, be his or her own verdict, the result of his or her own convictions, and not merely an acquiescence in the conclusions of the other jurors. Still, in order to bring 12 minds to a unanimous result, you must examine the issues you have to decide with candor and with a proper regard and respect for each other's opinions. You should consider that it is desirable that this case be decided. You have been selected in the same manner and from the same source as any future jury would be selected. There is no reason to suppose that this case will ever be submitted to 12 persons who are more intelligent, more impartial, or more competent to decide it than you are, or that more or clearer evidence will be produced at another trial. With all this in mind, it is your duty to decide this case if you can do so conscientiously. In order to make a decision more attainable, the law always imposes the burden of proof on the Commonwealth to establish every essential element of each indictment beyond a reasonable doubt. If you are left with a reasonable doubt as to any essential element of any indictment, then the defendant is entitled to the benefit of that doubt and must be found not guilty on that indictment. In conferring together, you ought to give proper respect to each other's opinions and listen with an open mind to each other's arguments. Where there is disagreement, those jurors who would find the defendant not guilty should consider whether the doubt in their own minds is a reasonable one, if it makes no impression upon the minds of the other jurors who are equally honest and equally intelligent, who have heard the same evidence with the same attention, who have an equal desire to arrive at the truth, and who have taken the same oath as jurors. At the same time, those jurors who would find the defendant guilty ought seriously to ask themselves whether they may not reasonably doubt the correctness of their judgment if it is not shared by other members of the jury. They should ask themselves whether they should distrust the weight or sufficiency of the evidence if it has failed to convince the minds of their fellow jurors beyond a reasonable doubt. I will now ask you, Mr. Foreman, and members of the jury to return to your deliberations with these instructions in mind. And as with my final instructions and the supplemental instructions I sent in, I will send in a copy of this charge as well. All right, so may that be marked, Madam Court Reporter, please.
So the jury will get
All right, so
physical copy of that instruction.
thank you. We'll send you folks back out to deliberate.
They're going to lunch and they're going back to deliberate. So the jury will be excused again. And again, it tells the jurors, if you have some doubt, the defendant is entitled to a not guilty. But if you don't have any doubt, you can't go against your convictions. And from that note, it seems like this jury at this point has very thoroughly made up their mind about the evidence. And they are not going to change. So I think that this jury is going to be hung at the end of the day. I don't think they are going to be able to change their mind and come back with a verdict, but it can happen. It does happen. I'll be surprised if it happens, but it can happen. And they can come back on one of the lesser includeds and not anything else. We'll see, but it can happen. So if the jury comes back with one more note that says, we cannot come to a decision, then the judge will declare a mistrial and they will let the jury go. If they come back and say they have a verdict, then we'll know the instruction worked. The goal of that instruction is to get them to come to a consensus one way or the other. And it really just depends on how they are split and how they are working with one another. So, what is the summary? The jury has indicated twice that they are deadlocked, that they fundamentally see the evidence differently, and that they cannot come to a consensus. And the judge has given the Tui Rodriguez instruction, also sometimes called an Allen charge. The language is different depending on the jurisdiction that you are in, but it tells the jury, go back. This is up to you. We want you to come to a verdict. If you're leaning towards guilt in this instruction, it says if you're leaning towards guilt, evaluate that position and see if there is any doubt that might push towards doubt. And then if they come back with another note, the judge will declare a mistrial because the jury is deadlocked. And then in most jurisdictions, the judge will pull the verdict or pull the jury about their split at that time. Not everybody does that way, but that's what you would normally expect to see, that the judge will mistry it and then ask for the split. So with all of that, we're going to get to your questions, and then I will be back live if we have any more from the jury today. They're just going to be getting back from lunch. I think we will see something from them towards the end of the day. I bumped my flight back to accommodate for that. So we're just getting to ride, and we will let you know both on YouTube and on the app when we are back. But I think that is what we are going to have here. So let's see. Dawn said, so the Allen charge is more in favor of the defendant. I think the Allen charge, and I would need to look at them language side by side, but the Allen charge, I think, focuses more on guilt. This one focuses more on doubt. So I actually think the defense probably likes the language of this charge better. I think that's why we saw the prosecution saying, no, it's okay, they haven't deliberated enough. And we see the defense saying, no, give them the charge. I think that charge focuses much more on leaning towards not guilty. Oh, Nicole said, Emily, you're not on Pacific time anymore. You're right, I'm not on Pacific time anymore. You're right. They're not at lunch yet. It's only noon there. They've got another hour to lunch. Everything I said about time, scratch that. I was still thinking I was on Pacific time. Thank you guys for understanding where my confusion was. I don't know what time zone I'm in. Are we in Central time? We're in Central time. We're in Wisconsin. Chris is with me. We went to Dave. It was lovely. We're in Wisconsin, Central time. So the jury has an hour until lunch. And then the judge has said between 1 o'clock and 2 o'clock Eastern time, she will not be taking questions or a verdict. So we'll see what happens from here. All right. With all of that, they've got about, the jury's got about another hour to deliberate before lunch. We'll see what they do. If I need to go live again, we'll go live again. All right. Let's get to some of your questions, and then I'm going to rest the voice, and we'll be back. I think the jury will be resolved today. I think no matter what, they're not coming back tomorrow. I think we are in the home stretch here, law nerds. I will be very surprised if they go home for the day. They had the whole weekend to think about it. We're coming up on 4th of July. I just think by the end of today, they're going to be like, no, we're done. We're absolutely done. Let's get to questions. Ashley has been a member for 15 months and said, I keep having nightmares I'm a juror in this case, I think is what that says. That it would be hard. Look, deadlocked juries are frustrated because imagine that you feel strongly one way or another about this case and you're like, it obviously must be this. How do you disagree with me? Right? And I've seen a lot of you in the chat being like, after those biomechanical engineers, how do you think he was hit by a car? So I see a lot of you also frustrated. The chat calls Emily D. Baker to the stand. I'm not at Summerfest. I went to Alpine. It's a whole situation. Are there any other avenues to go down before mistrial? No, Ian. They are at the end. This is the end of the road. I would sing, but I literally cannot. We are at the end of the road here for the jurors. The first was to go back and deliberate. The second was, here is the charge. The third is going to be 3 strikes, you're out. Like the third is going to be done. So the next note they get is going to be if they get another vote, or if they get another vote, If there is another note from the jury saying, we really cannot come to a conclusion, that's going to be the end. So the Slay file says today is my 31st birthday. Hope we get a verdict. It looks like that's increasingly unlikely. So other chats are hard. So happy you're jumping on. Rosebuds for fun. I'm hopping on. And again, reminding the Lawnards, we do not know the split. We do not know the makeup of the jurors. We do not know what is going on in that deliberation room. Jurors can surprise you. So just wait until we have the facts. I'm not going to dive into any speculation on that. I'm going to wait and see what the split of the jury is, and then we'll talk about it when we have facts, because we just don't know. All right, let's keep going. Michelle said, it's my birthday today. Hoping there's multiple of you with birthdays today. Everybody in the chat who's having a birthday, happy birthday. I don't think we're going to get to a verdict. Sherry said happy Canada Day. Thank you, Sherry. You are not the only one. Malarkey also said happy Canada Day and has been a member for 20 months. Everybody, there is no verdict. The jury was issued instruction. Thank you. I don't know if there was stress, but that is what it is. Carly, thank you for going live. You are welcome. Patty asked a great question. Patty, thank you for being a member for 26 months. If there is a hung jury, does the Commonwealth have to retry it? No. No, they don't. The Commonwealth can simply say, we're not going to pursue the case. Do you think Lally would do that? Come on, chat. We're getting close. We'll talk, members, we're going to talk about Jordan the Stallion later because I met him at VidCon and he is an absolute delight. But we're going to talk about that in a members only live stream soon. But I just can't see how this jury is going to resolve their issue. So Lizzie said, why did the judge not poll the jury? Because she sent them back in. The judge will poll the jury at the end. And I don't know if this judge would poll the jury every single time they came back with a split or not. It really depends on the judge and the jurisdiction. I think this judge is also maybe too mindful of how public this trial is. The jury asked for evidence that's not there. They tried to avoid this. Keep your receipt for your alibi. That's very true. They did. They asked for a police report that they could not get. And the judge said, you have all the evidence in this case. So, and good to see you, Annabelle. Thank you for the live. I needed this after the house fire. Oh no, I'm sorry that you had a house fire, Ann. That's awful. I'm glad you're in a hotel. I hope insurance handles it swiftly. And I'm sorry to hear that. That must have been incredibly stressful. Mebo B said, if mistrial, can the jurors speak out? They can. Ask yourself, chat, let me know in the chat. Maybe we should do a poll. If you're a juror in this case, would you want to speak to anyone in the media about this case? Would you want to talk to anybody? Or would you be like, don't know me, don't talk to me, don't talk to me at all? Would you want to talk to anyone? So, for those of asking, why can't the police reports come in? Police reports are not evidence. They don't come in cases. They don't come in. Expert reports don't come in either. Sometimes charts do, but no. Police reports don't come in. It was not improper to keep it out. It was proper to keep it out. It was never admitted into evidence. It shouldn't be. Unseen King said, I found a twin here. It's my 31st birthday today too. Happy birthday, twin. I hope you're having a great one. You guys, there's a bunch of you having birthdays in the chat today. All the July 1st babies, happy birthday. Can the jury do interviews with the media, even if it's a mistrial? They can. I don't know if they'll want to. Do you think they will retry, or will it depend on the split? Jen K, that is a great question. I would love to tell you. I would never make that decision without knowing a split and without hopefully talking to some of the jurors. The jurors can talk to the lawyers. And it really depends on what the jurors have to say. And it really depends what the jurors were convinced by or not convinced by. So I personally think a lot of factors should go into that. I can imagine a scenario where a DA would just be like, we're going to trial on this till the end of fucking time and just do it again. 2 trials is not wild. If you get to a second mistrial, there's a lot of questions. Do I think this case would be really difficult to retry? Yeah, I think this would be really difficult to retry. But then again, you know my opinion on this. I think with the accident reconstruction testimony, I probably wouldn't have tried this case in the first place. So it's harder for me to wrap my mind around what would be done if oh, hey, Dr. B and the kids. So the kids say I have post-concert voice. I definitely do, boys. I definitely do. So I can see Lally being like, we're go again. So for those asking, will we definitely find out the split? It depends on the judge. I don't know. They should, but I don't know if they will. And that's not necessarily required. Micro Kimmy said, what if it's hung and she's retried? Yeah, I can't imagine her being able to afford this defense team again. I'm worried the longer it takes to get this verdict. I don't know if they're going to come to a verdict. And yes, there is definitely a cost to this, more so for the defendant than the state. Lauren said, best emotional support lawyer a chat could ask for. That's what we're here for, chat. We're here to take a breath collectively and go, okay, we're going to see. Nicole said, baby contact naps made even better with EDB. Good to see you and happy snuggles. Jessica Hicks, member for 25 months, 2 years plus. Amazed at how much I love you guys. I love you guys too. I love seeing you in person. A love from Callie, drinking water in my Lawnard cup. Amazing. I did not travel with mine. I was worried. I traveled with so much this time because I've been gone for 100 years. I've been gone since last Thursday is when I rolled out. So I could stream Friday from a hotel and then stream Monday, Tuesday, and Wednesday from a hotel and then stream here again on Monday from a hotel. So yes, I didn't want it to break. And I had a lot of shit to bring with me. Michelle V said, good morning from Long Beach. Love Long Beach. Priya said, thank you for all you do. The wait is long. Waiting for a verdict is a very uncomfortable feeling. It really is. And knowing a jury's hanging, you just kind of accept it. So at this point, the lawyers are kind of in the acceptance phase. It seems like Lally is still kicking a little bit, but the lawyers are in the acceptance phase of, well, this jury's going to be hung. That one chick said, thank you so much for covering this trial. You're welcome. We have the best chat. We do. Love hanging out with my fellow Lawnards. Me too. The Lawnards are the best. I can't believe they are hung. I know. It's interesting how perspectives can differ, I guess. And that is why 12 people are on a jury. Brianna B77 said, if the jury is officially hung, will the court document the split? They should, but I don't know what this court's practice is. Today is my 60th birthday. Wintry Rich, happy birthday. So happy to be here with my Lawnard family. Look at y'all. Can we leave the stream open so we get a notification? Because apps, if we leave the stream open, you won't get a notification, though. That is part of the problem. When we populate a new stream, YouTube will populate a notification and the app notification, which should not, for some, it seemed like it was lagging a bit, but it should not be. Kathy said, can you please break down the jury statement? The jury statement, I think we broke down pretty well. I hope the jurors have tried. And it is no matter of anything other than they just see it differently. Like, you're not going to convince somebody. You just see it differently. So there's that. Nicole said, if there's a retrial and the Commonwealth does move to try again, do you think it would be wise to request a bench trial since there's such a lack of actual evidence? Well, the jurors weren't convinced about that at this point, Nicole, which is what's hard here. If the jurors were convinced that there was a lack of evidence, we wouldn't be here. They would have come back very quickly with what are you talking about? Not guilty. But they didn't. So there are some jurors that are thinking something. If the Commonwealth has a chance to talk to those jurors, it will inform them better about what to do going forward. But no, the defendant's entitled to a jury. So do I see the defendant waiving a jury trial for a bench trial after this? I don't know. But the Commonwealth's also entitled to a jury. And do I see them waiving that? I don't know. So no, I don't think it would ever go to a bench trial on a case this serious. Rhapsody and Blue said lunch already. It's only 11:40. I thought I was still on Pacific time. I thought I was working on a 3-hour delay, not a 1-hour delay. Tiffany said, I need this trial to be over. I mean, you and me both. I had a dream the jury called me to talk about the case and I had to scream at them to stop talking about it. The fact that you guys are dreaming about this case is not good. We all need a minute to take a break. Miss Mandy React said, I've missed you the last few days. I've missed the Lawnards too. We're gonna talk in a members only about VidCon and all the rest of it, but we've got to also I've got to take a minute to rest my voice, but we've got to get ready for the Baldwin trial that starts July 10th. So we're all going to be right back here in like a week for the Baldwin case. So We all need just a minute, and it's going to take a minute. Day said, or die in your arms tonight? Yes. Said, do you see Lally retrying this or letting it go? I want to know more about the jury, but I would be hard pressed to say Lally's just going to let it go. Do you guys think he's going to let it go? I mean, I don't know. He's still fighting to hold on to this one. Ryan's Hex said, if they all agree on the main charge is not guilty, does that charge get dismissed? Yes. If they return a verdict on some of the charges, but not all, those charges are done and cannot be retried. Loch Nessie, what a show set you got last night. Oh my God. Yes. And I called a bunch of those songs on like the weather makeup list. They played JTR. They played JTR. They played Halloween. Like it was very much we're so sorry about the tornadoes. Here you go. It was a great, great show. Warehouse, we got to do all the woos. It was so much fun. Thank you for this stream to keep us worried law nerds updated while we wait. You're welcome. That's why we came on stream. I figured it was more than I could message out in a message because I knew you guys would be worried. Like, what does this mean? What this means is we're probably going to end up with a mistrial. Less is more, Lally. Less is more. He very much does not embrace that philosophy. Sean said, if you take out Lally's rambling and redundancy, they only heard a week of testimony. Maybe 2 weeks, Sean. Do the instructions ever change the juror's mind? Sometimes, but not often, especially when they said they have a really kind of deeply held conviction on this. So it's not going to be easy to change their mind. Can the judge make a verdict instead of a mistrial? No, Megan, the judge cannot do that. Your mom said, how tense is it in that jury room right now? Probably very. They're probably really not happy with each other. KO, with vids, it's really hard because I get so many links sent to my email that we don't, we kind of abide by don't click the link. So if you want to tell us what it's about, sure. Tessa Mack in chat says the note is on Twitter. The note is on Twitter. Those are part of the court record, so the media would have access to the notes so they can screenshot the notes. So yeah, the media has access to those. They're part of the court record. Aaron said, based on the instruction and the jury form, I'm not sure this jury understands they can acquit on the primary and hang on the lesser includeds. They might not understand that. Roy said, I am not guilty all day, every day. Miss Ophi said, in case of a mistrial, will the judge do a poll before the jury is excused? I would think the judge would, unless the judge asked for it on a note. I would think the judge would. We'll see. Samantha, did the instruction work in the case it came from? I would have to go back to Massachusetts case law on that. I don't know. On the case it comes from in Massachusetts. Each jurisdiction has different cases. But I think in the Allen charge case, part of it was it went up to saying the language was too strong, and the court came back and said, no, the language is not too strong because it shifted that split to a conviction. Pepsi Man said, happy to be back in court. Hope you had fun, EDB. I did. I'm tired, but I had fun. Are the jurors thinking, now what? Probably. But they also probably understand the judge said, this is what we're hoping for. But if you can't come back, you can't come back. So I get it. Massage Girl said, with that language, shouldn't she just have declared a mistrial? What if the jury thinks she's telling them they have to agree or they can't leave? And that is why those instructions go up on appeal. And the courts have found that they are valid. But the jury doesn't have to do anything. They can come back again and say, we still can't agree. If mistrial jurors are polled, yes, do jurors know they have to state an individual position? I don't know if they know that. Do they get polled if there's a mistrial? They should, but I don't know what the judge will do in this jurisdiction. Jay McCarthy said, listening to this verbiage, I can see why the Commonwealth wanted to avoid it. Yes, it really asks people who are leaning towards guilt to question why they're doing that. Do they tell the jurors what is available to them, like read back, or do they just let the jurors ask? Or do they just think that the jurors know to ask? They do not tell them what's available. They say you can ask us questions. So, and the jurors did ask for something and were told you have all the evidence. So I don't know if readback would help if they see the evidence differently. Shauna Banana, member for 10 months, says, for the sake of justice, I hope the FBI comes through. We may never hear, if there's no indictments, we may never hear what that investigation renders, but we'll see. I'd rather a hung jury than an innocent person be found guilty by strong arm tactics, Trophy Wife said in a super chat. Angela said, if this case is retried in a different courthouse, does that mean a different judge? Not always. Love you, Emily, and this community. Angela, I do too. I love this community. Do you think that not being able to have the transcript read back has an impact on this? They could have the transcript read back. I haven't seen that they asked for the transcript to be read back. They could get read back if they needed it. I don't like this chair in this hotel. Nezu said, love you. When does Baldwin start? July 10th. Way too soon. Way too soon. Don't worry, law nerds. We'll be back in day-to-day trial imminently. Lindsay said, if they retry, will it be immediately very short delay or will there be some time? It depends on the court's schedule. If there's a mistrial today, I imagine the court will set a hearing in like 30 days to figure out what's going on. So that's what I think will happen. And the prosecution will probably not announce today if they're going to retry the case or not. That normally will happen at the next hearing or the next hearing down the road. If juror misconduct comes out, what happens? It'll be looked into, but it doesn't undo if there's a mistrial. Law Nerd Soph said, I'm so irritated. It feels like they're basing the verdict on opinion and not the evidence. They probably don't feel that way, Law Nerd Soph, but I get it. When you see something fundamentally one way and somebody else sees it fundamentally differently, it's really hard to be like, I don't even understand. I don't even understand what you're saying. So let us continue. Dyslexia. That is a hilarious name. I love it. I think it's amazing. Question. Hi, Emily. Been a huge fan. I wanted to ask how you would like fan art sent to you. Send us an email, but we have a PO box as well. That's very kind. You never have to do that, but thank you. And if it's digital, we have a public email address. Kim said, can I get a shout out to my 4 and 7-year-old nieces? Kim's 4 and 7-year-old nieces. Hi. I hope they find a verdict. I don't know if that's going to happen. If they're hung, can they add charges next time? I mean, they can explain the lesser included. It's better. There's not really much more to add in this case, unless they're going to try her on like a DUI. Sage said, what do you mean charge? The jury charge, well, it depends on what context I was talking about. Sorry, this was a minute ago. But the jury charge or the Allen charge or whatever, it is an instruction given to the jury. So they are being told what to do. So it is being charged to the jury. Kelly said, insanity, this jury. I feel for this jury. They are normally quite at odds when they come in and out of the courtroom when they are hung. So please explain the square-like box pillow. That's the pillow I travel with because it doesn't hurt my neck and I'm allergic to feather pillows. And sometimes hotels don't have any other option. Even having the feather pillows in the room, I'm still stuffy. Carrie said, would you retry this case if you were the prosecutor? I wouldn't have tried this case in the first place if I was the prosecutor. So it's real hard for me to wrap my head around how we're going to do that again. Robin said, do they only get testimony and evidence to review? Yes. They don't get the demonstratives. They only get the things that are in evidence. They have 600 exhibits and evidence, but they can rewatch video, re-listen to audio. The thing is, if they disagree about whether or not the victim was hit by a car, I don't know what you review. What do you review to convince somebody else? So Leanne said, what's the difference between the Allen charge and the Tui Rodriguez charge? I would need to literally take both jury charges and line them up, but it's different jurisdictions. So different jurisdictions use language that comes from different case law, but I would need to line them up. Lorna said, I miss your background. I do too. I absolutely do too. But it's either this or no stream. So hopefully this is acceptable. Patricia said, I hope the Commonwealth doesn't retry the case if the verdict is hung. They have the obligation to. So we'll see. Joe Jersey said, I'm 54 today. So many birthdays in the chat. Hold on. Everybody needs a round of applause for their birthday. Hopefully this is applause. Oh, I did it right. There are so many birthdays in the chat. Melissa McSweeney said, how confident are you that jurors have no knowledge of the federal investigation? I think I'd be mad if I was a juror and found out later. Yeah, I'd be mad too. Honestly, Melissa, I'd be real mad about it. But there's the other proceedings and there's the other indictment, or not the other indictment. There's the other proceedings and the other transcripts from the other grand jury. There are definitely some hints that there's a lot going on in this case. But yeah, I'd be mad too. Heartless Soul said the jury will wait until I'm milking cows again. I have so many questions. Are you also in Wisconsin with me? No. I have so many questions about what time you choose to milk the cows, how long it takes to milk the cow. I have all kinds of cow milking questions, but I'm going to leave those for another day. Because yes, this jury will come back when it is the least convenient time. Jay Fernandez said this trial has been nothing but fuckery. I can't believe with all the evidence the defense put forward disputing that John O'Keefe was hit by a car that there's a jury deadlock. I don't understand. If you look at those lesser includeds, I don't understand if they're hung as to the lesser includeds. But if you look at those lesser includeds, some of them are chain of events, and none of the lawyers explained it. So I'm not going to be ragey at this jury because we don't have the information and we don't know what they're looking at and we don't know what counts they're looking at. But those instructions on those lesser includeds are confusing. And none of the lawyers explained them. So, yep. Do the jurors have to give feedback to the lawyers if a mistrial happens? They don't have to. Liz wears what? They can, but they don't have to. So we will see. Let's see. The painting behind you is the Milwaukee Art Museum. If you have time to see it, you should go. It's incredibly beautiful in person. It depends on what this jury does, because I am not going to be far away from my streaming setup until we have an answer. EDB, you binged at 780. Congrats. Thank you so much, B. Vargas. I appreciate it. Susie CJ, Mass doesn't allow transcripts. A local attorney explained. Interesting. I'll have to go look for that. Also, I rewatched Instructions with the panel yesterday, and another attorney shared that this morning. It's interesting. I mean, they didn't ask for it, but that's interesting. Look, every jurisdiction has its own quirks. I've not seen this jury ask for readback and told they can't have it though. So, it's not as if they're saying, can we hear the testimony of this person? And they're being told no. They've not asked for that either way. So we'll see what the jury decides to do. How long before we have a verdict mistrial? Brett Bottoms, gosh, I wish I knew. I would say by end of day. So 4:30 Eastern. Nor KD, need a round of applause for you finding the right button. I'll take that. I'll 100% take that. 100%. So Jonathan said, surely the state will be hesitant to retry with the FBI investigation looming. I don't know. Could be very awkward. This was very awkward. Please say hi to my gorgeous girlfriend, Mel. Jonathan's gorgeous girlfriend, Mel. Hello. It was awkward this time around. So I don't know what they're going to do. Everybody wanted more time before going to trial on this. So I think they're going to just want more time before they have to go to trial again if they decide to retry it. Question, if Karen is acquitted in the case, will she be free to testify in any federal case? Yes. If it's a hung jury, she will not be free to testify, correct? I mean, she could waive her right against self-incrimination and testify. I think that would be a terrible idea. But if the jury is undecided and the jury, my brain is so tired. If the jury is undecided, she is still pending trial. So she is still in jeopardy. So her Fifth Amendment right still attaches. If she's acquitted, double jeopardy applies and she can't be tried again on all of this. So it's very different positions. She could still choose to waive that right. She could be given some type of immunity. There's still lots that could happen. But in general, if the jury is deadlocked and it mistries, it's like you still have a pending trial over your head. And that's not fun. Day 12. Oops said day 12 of asking for a Law Nerd themed DMB fire dancer. We'll see about it. It's hard because I know the fire dancer is IP lawyer. Like, God, Emily, do you sound like a lawyer? The fire dancer is technically the IP of the Dave Matthews Band. Yes, I do. But we will see what we can do. We will see. Dave is very much about the fan art. Like, could you imagine the Dave Matthews Band being like, you can't tattoo fire dancers because they're copyrighted? I can't even imagine this band doing that. But it is something I will consider. The DMB law nerds have asked more than once. Cheryl said, I truly appreciate your thoughts and your wisdom. Thank you. More importantly, you got to meet my dear friends, Katie and Greg, at the original canceled Dave Matthews concert, and they got to meet you. Yes, and they were lovely. Look, I had so much fun seeing the DMB EDB law nerds. It was a really, really great time. And night one at Alpine was lovely. I'm kind of mad I missed Creekend, but VidCon, and we'll talk about that another time. But Creekend had great set list too at Deer Creek. And so, I don't know. This summer, the summer schedule of Dave and the summer schedule of my life have not played well together, but I'll get to see them again in September, and it's all going to be fine. It's all going to be fine. Stephanie said, all I am filled with is reasonable doubt. I get it. Stephanie, I absolutely get it. Like, I absolutely get it. I absolutely get it. I think most of the chat is like, look, this is where I'm at on this case. And I think a lot of you are with me. I still don't know what happened. Like, I still don't know what happened. Like, I still don't know. I still have so many questions. And if I have so many questions, then I'm not there. I know some of you are like, this is a case where where Karen Reed is 100% factually innocent. And some of you are like, how are you fooled by the defense? Do you not see through the smoke and mirrors? And I'm like, I have questions. Angels Above said, Emily, you have to go to Culver's for lunch or dinner. They are so good. We have Culver's in Massachusetts, and I will probably get coffee before I do anything else. I try to find locally owned places when I am traveling, and Culver's we have in Tennessee. So I would be like, yeah, we'll hit that at home. How long does the Commonwealth have to retry the case? Jessica, it depends on jurisdiction. Some jurisdictions start the clock over. I don't know what Massachusetts will do. Look, I didn't know they were going to start court with hear ye, and God save the Commonwealth. So we'll see. Will I take a look into it as we get there? Yes, but the court's going to have a hearing. Will I keep covering it if this case hangs and there's hearings? Yes. Will we look into the federal investigation, all those, the letters back and forth with Lally and stuff? Yes, we'll look at all of that. I haven't looked at any of it yet. Happy Annie asked, will we find out the split? I hope so. I'm not going to answer any more split questions just because I don't know what this judge will do, and I hope so. Senorita said, how did you like Alpine? Were you there when they had to cancel because of weather? I was there when they had to cancel because of weather. I love Alpine. My knees don't love Alpine as much as the rest of me, but it is a lovely venue. The Dave crowd is amazing. The sound is great. Last night, the cool air felt so good. It was just so nice to go to a summer concert where I didn't feel like I was going to die because it was 95 degrees and 95% humidity. Like, it was really lovely. Really, really lovely. One of the reporters indicated the juror was crying and others seemed upset. They are probably emotionally distraught. If they say guilty, can the judge overrule that? No, not at this point. The jury verdict stands. I mean, the defense will ask to set aside the verdict and for a judgment notwithstanding a verdict. But no, they can't come back in and the judge goes, disagree. If there is a verdict on any of the counts, there's nothing the judge can do with a not guilty. It's an acquittal. That's it. If a guilty verdict comes back, then there will be motions for a judgment notwithstanding a verdict and other types of motions. So those will happen down the line. Jacqueline said, as a former juror, last thing I want to do is talk. I would imagine so. And Bell said, everyone, even the paw nerds got out safe and sound. No one was home. Law nerd cups were lost, though. And we've got you. Don't worry about that. Laura M. said, if the Commonwealth retries it, ends in another mistrial, what happens? They can retry it again. Thank you for being here with us. Also, still asking for toddler-sized law nerd merch. That is a sourcing thing, and thank you for that. But they can retry it again. Kathleen said, I hope to hear from the last witness dismissed and number of not guilty. We won't hear from any of the witnesses, especially if there's going to be another trial. I don't know if we'll hear from the jurors. Susie said, what is the negative aspect of a hung jury versus anything else for the defendant? Can the judge do a bench verdict? No. Is it more likely to retry? It depends on the split. But with a hung jury, there's no certainty. So if the jury is leaning towards guilt, a hung is way better for the defendant. Like if the jury is leaning towards guilt and a few people are undecided on that, it's way better for the defendant to have another shot at another jury. If the jury is leaning towards not guilt, then I think it would be much more frustrating for the defendant to be like, can you just let us be done? So it depends. Renetta, it is a TUI, which I think is THUEY, but I would have to see it while I'm saying that. It's a TUI Rodriguez instruction. Their last names based on the case law. So not Thule. No. Hopefully that helps. I'm going to do a few more questions, and then I am going to take a break. I will let you know if we need to go live again today. Rose Marlia said state of Massachusetts strongly discourages readback, stating it favors the prosecution. I mean, I guess it really depends what you read back. I don't know if readback favors anybody, but you have to listen to the case when it's happening. So I can understand a split in opinion on readback and whether it's good or not, because the jury should be paying attention to the live witness testimony, and hearing the words absent seeing how somebody testifies can be a problem, but it's weird. So let's see. Are you seeing David Gorge in September? No, I'm not going to the Gorge this year. The timing did not work out. Music to My Soul said, how do you have a neutral witness say that there are infinite possibilities for injuries except a vehicle conclusion and not have reasonable doubt? I don't know. But also when you look at those lesser includeds, it is hard. The lesser includeds are confusing and none of the lawyers explain them. So I don't know. We'll see. Maybe they're decided on some counts, not all. Maybe they're not. Maybe they're not decided on anything. Maybe some of the jurors are like, no, she hit him. It sideswiped him and he hit his head on the thing. I don't know. Grace B. Creation says, what's the purpose of the Rodriguez instruction? To strongly encourage the jury to reach a verdict. Josh said, if there's a mistrial and it's not retried, can that affect Karen's ability to pursue civil case considering she was never found not guilty? I don't know. I would have to know more to actually give you a strategic, like this is a better outcome than that. I would have to know more. I swear I'm still cool. Asked about Bourbon and Beyond in Louisville. I don't know. Wedge, good to see you. What do you think that the judge didn't accept a hung jury the first time? They never do. Wouldn't that be a type of verdict? Or why do you think the judge didn't accept the hung verdict the first time? They never do. Judges, they never do. I have never seen a judge when a jury comes back saying, we can't reach a decision, say anything other than go back and try again. This is the really normal process. 3 times. Go back and try again. Your Honor, we went back and tried again. Okay, here's an instruction telling you, really, really, really go back and try again. And then when they come back again, then it gets accepted. This is a very, very common procedure and practice to not just the first time say, no, we're done. Amy said, wore my Leonard Unite tee to the grocery store and the cashier asked if it was a Star Wars Pride theme shirt. I said, kind of. Toss some 80s gaming and Leonard love and you got it. He was geeking and I was so excited to share our community with someone new. That's amazing. And once again, that's why we make merch. That's amazing. If it is retried, can they change the charges? Not really. Could the Commonwealth try to prove John died in a different way? That would be really difficult based on the charges. Not being hit and thrown by Karen's car. It would be very difficult if they retried it because all that evidence is in. What are they going to do? Have the Commonwealth's accident reconstruction expert be like, just kidding. I completely changed my mind. No, because then they'll grab all of the old transcripts and be like, but you didn't then. So we will see. With that, I know you guys have a lot more questions. I need to take a break. We will be back if the jury comes back with anything that we need to cover. So, Just Bree says, why does the defense want a hung jury? I think the defense wants to give that strong instruction and move on and be done. The longer they go, the less helpful it is. This jury is clearly at odds, and that's not going to resolve. So I think the defense would rather see what happens in the federal investigation and hope that sways the Commonwealth against retrying it. I think the defense, no verdict for the defense is better than a guilty on even one of the lesser includeds. Remember, the involuntary manslaughter lesser included still carries 20 years of prison. So I think for the defense, they rather have the jury be like, we can't make a decision, than be like, okay, we'll make a decision on one of the lesser includeds and call it a day as a compromise. I think the defense rather have that not guilty, they obviously rather have the not guilty, but I think they rather have the hung than a compromised guilty on one of the lesser includeds. So that's what I think. And that's where I think they are ready. They are ready for the jury to just be allowed to be done. And depending on what they know about the federal investigation, they might think there is room for them to negotiate or leverage the Commonwealth into getting rid of this case. So we'll see, but they're not back yet. They're going to go to lunch. They're going to go to lunch in about 20 minutes. The court will not take anything between 1 and 2 p.m. Eastern. So all of you take a deep breath, go get some lunch, hydrate, or breakfast, depending on where you are in the world, or dinner, or I don't know, happy hour. Where are we in the world? All over the place. My brain too. So take a minute. This jury will not be back between 1 and 2 Eastern time. And we'll see what happens when they come back after that. Josh said it's 3 a.m. Sydney. No, don't take anything, Josh, but a nap. It's bedtime in Sydney, but I'm glad you're here. Law Nerds, thank you for being here. Thank you for being a Law Nerd. We will be back. Leona said it's 5:40 p.m. here in Ireland. So it is happy hour somewhere. When I say it's 5 o'clock somewhere, clearly what I mean is Ireland all the time. It's 5 o'clock somewhere? No, just Ireland. It's 5 o'clock. Law Nerds, you're the best. I will see you at some point later today, won't I? We know something's happening later today. So keep your eye on the Law Nerd app. And as always, we are working to make sure you get those notifications as fast as possible. Make sure your notification settings are all dialed in and are turned on and are not in your scheduled summary so that your notifications come across the front of your phone. I will see you very soon.
You can stay up to date with everything I'm covering and fast notifications on our free iOS and Android app at lawnerdapp.com or search the App Store for Law Nerd. You can also follow me around social media, and don't forget to check out my podcast, The Emily Show, with quick bits dropping every Monday, summarizing everything I do here on the live streams on Tuesday and Thursday for when you just have time for the quick bits. Thanks for being a Law Nerd.